extended family member, then that person is an extended family member. If it's part of their custom, if very, go ahead.
I've never thought about this till just now. If ASPA is federally based legislation under Title II and so is ICWA, how do they deal with placement? I mean, does the tribe supersede any kind of issue as to like
So
ICPC issues that would come in?
ICPCs aren't really required. ASPA is a little trickier. There's still, there's a lot of statutes that delineate this with much more detail than I intended to go into today. But basically, there's still requirements that they can't have any, there's an enumerated list of convictions of like really bad things. There can't be a convicted rapist or child molester. But the tribe can do their own home studies, can do their own reviews of the homes. They do have that extra resource that sometimes can help you get around some of these requirements that maybe ASPA's a little bit more strict about. However, there are delineated convictions, home issues that basically will, whether the tribe approves it or not, it's not going to get the funding. And
But whether there's funding or not, can the tribe delineate placement and use, and just say the tribe will take placement, or we want the kids' placement?
as long as it's not one of the completely, like one of them is they cannot have a conviction of child sexual abuse on their record, you cannot place in that home. And whether the tribe says I'm okay with it or not, you cannot place in that home. I don't have the statute offhand because it gets a lot more complicated when you're dealing with adoptive home studies where you're placing a child for adoption. Maybe you're trying to, there are ways around it with the tribal resources, and I'd be happy to talk to you about it in much more detail because I have papers with a lot of that research. It just seemed a little too dry and legal for our purposes. Most importantly, here, you want to, again, make sure that you have the tribe involved because they're going to be helping you to define who an extended family member is, and that is your first priority. So if you can get someone defined as an extended family member, whether they're a long distance, very not really related, but they're a step. I have one where it was a step cousin of on the paternal side. The tribe says, you know what? We recognize all step family of any distance, any relation. They are extended family in our custom, and the court had to place there unless they could find good cause otherwise. This case here in Ray Brandon M says de factos or extended family members. Don't really care for that. I think it's very distinguishable if you have a case where this comes up. In Ray Brandon M, the court basically said that this dad, who was a step-parent, he was married to mom when the case came in, so he qualified under the statute. However, a divorce happened. He is no longer a step-parent. He is not anything, but he had raised these kids for most of their lives. He was, for all intents and purposes, their father. He filed for de facto, and the court granted him de facto and then said that under the statute, I believe that if you read in the case that what they were trying to say, that within the spirit of the statute, as a de facto who was just recently one of the delineated family members, we believe he qualifies as extended family. So I'd urge the courts to, if they're going to use that case, use it very limited. Other members of the child's tribe and other Indian families. Any of those can be your order of preference. Now, the only way that you are able to delineate from the order of preference is if the court can find good cause. This is where things get a little muggy. The court may determine good cause exists not to follow the preferences if your client has a different preference. If they say, you know what, I'll make it work. I want my child placed with family in Utah. I'll make it work. Even if I'm in reunification, that's what I want. or if a child of sufficient age has a different preference. It does not define of sufficient age. I would go with what other things we use. You know, can you qualify a child? If you can't qualify them, they're not of sufficient age. Perhaps age of 12, which is, you know, when you're consenting to adoption. California Rules of Court indicates that the good cause may include the request of the parent or Indian custodian, the request of the child when of sufficient age, extraordinary physical or emotional needs of the Indian child as established by a qualified expert witness. Here we go again with that qualified expert witness. And then finally, if there's an unavailability of suitable families based on a documented, diligent effort to identify the families. This must be documented by the department, who they've contacted, when they contacted them, what resources they were using. They must have contacted the tribe to ask them. They should have contacted any and all family members who are alive and available to ask about friends, relatives, neighbors. Now, this is what the law says right now. I thought it was pretty clear what good cause requires. However, in Re Alexandria P, which was filed August 15th, says that the court, in our case, committed 3 legal errors in interpreting the meaning of the term good cause. And they don't really say what they feel about the old standard of good cause. So I'm sticking with what we had before, and what it seems the trend is going to be is that we now also need to sort of consider these things. Going forward, if it comes up, I would make sure that these things are being considered, even though it's not really citable yet. I wouldn't want your cases getting overturned on the same basis. So the court said that you need only show there is a significant risk that a child will suffer, sorry, there's a typo in there, will suffer serious harm as a result of a change in placement. This is a new created standard. I don't know where it came from. Basically, they're giving the foster parents who have these children a little bit of an upper hand and turning them into parents, saying that you need to show us a significant risk that the child will suffer serious physical harm, not this certainty, which in the Alexandria P case, the court made mention of certainty, which I believe came from number 3 here. She made mention that there was no certainty that this child was going to suffer any physical or emotional trauma as a result of the move to, basically she was with foster parents here in LA. We're trying to get her with relatives out of state. Court said no certainty. Appellate court said we're not looking for certainty. We're looking for just a significant risk. If it looks like this child is going to be upset that she's moving from her foster parents, maybe that's significant risk. I don't think so, but that's kind of what the court seemed to be alluding to. So make sure that you're really harping on, if you're dealing with a good cause hearing, which I urge us to be bringing these up a lot more often. I know that there are ICWA cases all over the building, and I know that a number of those cases don't have kids in homes of family members. A lot of those placements are deviating from the placement preferences. And so I urge us to, especially if your client really wants a kid placed with a family member and they're not someone who is clearly a horrible person, that we set these good cause hearings and focus on showing that there is no really established risk that this child is going to suffer any harm in result of a change of placement to a family member. I still think that what this court ignored is that a qualified expert witness is required. So make sure that you're harping on that expert witness. Like, what is this harm being defined by? How do they know that this child is going to suffer any harm? Is this child different than any other child? Because wouldn't we all agree that in the most ideal circumstance, foster parents provide these kids with a nice home in the interim while our clients get our act back together? I mean, any normal child is probably going to bond with someone who's caring for them for an extended period of time. So just considering that the child is going to be sad leaving her foster parents, I don't think is a significant risk that there's going to be serious harm as a result of a change in placement. You've got to show something more. In this case, they're trying to say that, you know, that maybe this child is going to revert to like bedwetting practices and her biting herself and her trauma is all going to come back. That may be, if it can be established, a more significant risk of harm than maybe a child who's going to miss their caretaker. Secondly, the court said that you have to consider the bond between the child and the non-ICWA compliant home. That being the child and the foster parents, consider the bond and the detriment that the child might suffer from a change in placement. I think, again, this goes a little hand in hand with prong number one, but this is really, really bad for us. Because, like I just said, any kid is going to bond with someone who they're spending day in, day out with for any substantial period of time. It's just a consideration. So the court can look at it. It is not the sole factor. And I would urge you again to look at the other good cause deviations and the reasons for deviating from good cause. And maybe what this means for us going forward is that if your client has a relative who's available during reunification, even if they're out of state, if they can somehow facilitate visits, it might be worth it to consent to deviation from the reasonable proximity. Because if you end up in the long run with this, ICWA's operating as a double-edged sword, really is what it is. And they're saying that the children must be placed during reunification within reasonable proximity of their family. But then when you change to a pre-adoptive or an adoptive placement, now consider the bond that they've established that whole time with the foster parent that they were placed with so that the parents could reunify. It's a little bit troubling. It's not citable yet, like I said, but it's something to consider, and I would be very wary of it. And then finally, consider the best interest, which is, again, a created standard from the appellate court. I would urge you to tell our courts to look at 1902, the Congressional Declaration of Policy, and that's also codified in WIC, which says that it is the policy of this nation to protect the best interests of Indian children and to promote the stability and security of their tribes and families by the establishment of the minimal federal standards for the removal and the placement of such children in homes which reflect the unique values of Indian culture, and by providing for assistance to Indian tribes in the operation of the Child and Family Service programs. The ICWA itself built into it best interests of the Indian child as a kind of different construct than what we normally think of. This court said you need to consider best interests independently. I would urge us to go forward and telling our courts that best interest is built into the ICWA. It is in an Indian child's best interest to be placed with their family, their culture, and their tribe. Any questions about placement preferences?
Procedurally, when can you have the hearing? So what if you're asking this vote and there's no one supposed to be open?
Well, for a good cause hearing is any time that the court has deviated from the placement preference, and that usually would occur at dispo when the placement actually happens. So I would ask for, depending on how your case is going, but if the placement occurs at dispo, the child is suitably placed and relatives are available but haven't been considered, this child's now in a foster home or in a home that's of a more restrictive than the placement preferences suggest, then I would ask at that time for a good cause hearing. Also, this can occur, I'd say, anytime we get removals from relatives. Maybe the kid's placed with a relative, and for whatever reason, the department removes from this relative at some point down the line after disposition at like a 387 or just a simple removal, then you can ask for a good cause hearing right then and there. It can occur anytime that there's a foster care or pre-adoptive placement. And that's usually going to happen sometime post-dispo, but there's a lot of times where it could come up. Any other questions? Tribal customary adoption, just know it's there, it's an option. It's kind of a lot more complicated than this, and most of your courts are going to want to consult with someone if you suggest this as an option to them, but it is here. And at every 2-6 hearing in an ICWA case, the department does need to, in our normal 2-6 cases, they have to have explained the 3 options: adoption, guardianship, long-term foster care. In an ICWA case, they have to have discussed with the tribe the option of tribal customary adoption. And basically, you can have a tribal customary adoption in any case unless the tribe is unable, unwilling, or unavailable to participate in this consideration. And it operates virtually the same as a normal adoption, except for it allows for continued family and tribal connections. So technically, your client's parental rights are not terminated. However, they cannot file a 388 to, it operates effectively as a TPR for them. However, they are still connected. It allows the child basically to have benefits of the tribal resources, allows them to maintain their connections to their grandparents, their aunts, their uncles, all these people who are very important within the tribal community. And that's all you really need to know about tribal customary adoption. So I know it was a lot of information in a very short period of time, and I would love to discuss with you, Marlene, the implications of ASPA and these very confusing statutes that I'm not sure I fully have my own head wrapped around. And anybody else who has any other questions for me at any point, I'm always available by email. And if you catch me in the courthouse, I do not mind if anybody stops and asks me because I'm a super ICWA nerd. So.
So how many cases do you have left?